Patent Guy 97 says that the SawStop patent will expire next year. Is that true? I've read that every single year now for the last several years, and it still hasn't expired. Well, you know what? As a former state trooper, I had to investigate this to find out, is this the facts? So I reached out to a patent attorney who agreed to be interviewed on this topic. And in this video, we're going to cover, number one, when will the SawStop patent expire? Number two, is SawStop a patent troll? Because I've read that multiple times as well. Number three, when will other companies start using this technology if the patent's expired? Or can they even use this technology? And number four, while we're on the patent topic, let's talk about the Festool Domino. When is that patent going to expire and we get one of those at a much cheaper price? Let's go. Welcome, Michael Steele, a patent attorney from Cleveland, Ohio, to give us the answers about this SawStop patent confusion. How you doing, Michael?
I'm doing great. How are you doing today, Matt?
I'm doing good. Mike, can you tell me a little bit about your background?
As you mentioned, I'm a patent attorney, and I've been practicing patent law for 19 years now. And my primary focus is drafting and prosecuting patents. So when somebody has an idea, they come to me, I write a patent application, and then file it with the Patent and Trademark Office, and then deal with the myriad of problems that exist and the maze that is the patent office. And that's called prosecution. So you have the preparation and the prosecution. I don't do litigation. That's plenty of other people handle that. So I just handle the procurement side of things. Today, the way I got involved in all this is just as a hobby. I'm a woodworker. I've seen a lot of videos out there about SawStop, and I know there's people who have a lot of questions about it. I did want to preface everything that I'm going to say today should not be considered legal advice. I don't represent anybody that I'm aware of that's watching this video, and we don't have a attorney relationship or attorney-client relationship, but you can consider this just educational purposes, and I'll try to be as clear as I can. And I also want to say I do not work for any of the companies that I'm going to mention, so there's no conflict of interest, and none of them have ever paid me a dime, at least today. So.
And you're coming on here of your own free will. I'm not paying you for this either. So.
Yeah, absolutely. You know what? Honestly, it's just I don't get every day that you get a lot of questions about patent law, about what the hobbies that I'm in. So it's just more, just something fun that I want to participate in.
I appreciate it, man. So can you briefly explain the differences in the patents? From what I understand, there's a design and utility patent. Is there anything else I'm not thinking of?
Yeah. So actually, there's a third type that's pretty irrelevant, plant patents. But I don't think those would apply to woodworking. Overwhelmingly, the two largest are the utility patents and the design patents. So when you think of the design patent, what you want to focus in on is the shape and the ornamental nature of the product that you're going to sell, comparatively to the utility patent, which focuses on the operations of the device you're going to sell. So one great example of a design patent that does exist as long expired was the Statue of Liberty. So they had a design patent on the Statue of Liberty, and what that entitled them to do was prevent other people from selling those, small statues that if you go to the Statue of Liberty, they'll smell, because that would be infringement on the design patent. It didn't matter the scale of it, but it was just the overall look of that. So those are the two big areas that come into woodworking, is the design and the utility. Design are a lot easier to get, but they cover a lot less. They're a lot easier to design around. And then utility are more expensive and more time consuming, but they cover more.
And so we're talking about SawStop specifically. What patents do they hold on their saw, or this main thing that everybody gets hung up on?
SawStop has one of the best intellectual property portfolios of any company I've ever seen. And that's probably because Stephen Gass, the inventor, was a patent attorney himself. And so he spent a lot of time making sure that all their I's were dotted and all the T's were crossed. They had, at one point, well over 100 patents on the SawStop. Most of those have expired, but there are still a few out there. They used every option they had for extending the patent term as long as they possibly could. So
when did they actually patent their first patent on the SawStop, the actual stop mechanism, and then how long does that patent last? Because you always hear well, the patent's going to expire next year? I've heard next year for the last 4 years.
Yeah, and that's a great question. So it's a little caveat in the patent world that there's the type of patent that they filed at first was called a provisional patent. It's a utility patent, but it's not a non-provisional, which actually can issue as a patent. A provisional patent's often used for a situation where you don't know the market or something like that, so you just want to get something on the record and then try to go sell it for a year. It's good for 1 year and it's never examined. But then after that, you can file a non-provisional that quote unquote claims priority to the provisional. In that case, you get 20 years from the date of filing of the non-provisional application, which, because they filed the provisional, they got 21 years because they got 20 years plus 1 year. However, there's also ways that you can get term extensions if there's a delay from the patent office. So like when you're, as I mentioned at the beginning, I deal a lot with the maze of the patent office, and sometimes they go dark on me on a patent and I might not hear from them for 3 years. So in that scenario, you can ask the patent office and it's actually automatically granted. It's not just, it's a matter of forms and all of that. And they will issue you a certain extension of time for the term of the patent based on their own delays, if you can show that the delay was not your fault for the patent prosecution. And in this case, SawStop has leveraged that to their best advantage. And they have, from my research, which, again, they didn't hire me, so I'm only going as a hobbyist here, but my estimation that the last patent they have is going to expire in 2026. So they have managed to get a lot of time from their patent.
So do you know what year they actually patented the SawStop?
Well, I think the first one, if I remember, I think I saw somewhere that it first issued the first one in 2002 or something like that. But the issuance date is never something that I'm going to pay a whole lot of attention to because I'm going to look at the priority date because that's much more important to us. Because basically they had effective coverage from the time that the patent application was filed. So that's the much more important date.
So SawStop has been acquired by TTS Tool Technic Systems, which owns Festool. Does that change anything as far as patents go, or they just hold the patent now?
I actually looked into this, and interestingly enough, today SawStop itself is simply a separate entity from TTS Tool Technic, and in their case, I don't know who's running the show over there. It's sort of, it's probably just like one office, and all they own now is the intellectual property. Now, my guess, without having discussed this with anyone, is that they have an exclusive license with TTS to sell, allowing them to make and use and sell the SawStop today. Currently, the only thing that other company now does that owns all the patents is they will contact potential infringers and let them know that they're infringing. However, the only reason that they're doing that is because they're going to be obligated to under their contract with TTS. TTS certainly doesn't want to deal with competitors while they still have patent coverage from SawStop.
Right. How long realistically can SawStop keep control of this technology and prevent it going anywhere else? So once it expires, I'm assuming other companies could theoretically start putting this type stuff in their system, right?
Absolutely. In fact, I'm surprised at this point that we haven't seen more of it. If all of these major companies have their own patent attorneys working for them that are going to spend the time and try to figure out which exactly of the 100 patents are expired, and they can look at those, and as long as they're not infringing on the ones that haven't expired, they're okay. A good example would be the Bosch Reaxx saw that was released a few years ago. In that case, it was kind of an interesting situation because SawStop brought an International Trade Commission, ITC, action against Bosch to stop the importation of the Bosch Reaxx saw. And they asserted that they infringed on at least 2 of the patents, but the the Trade Commission actually ruled they only infringed on one of them, because one of the patents that they asserted had the brake. And I don't know if you remember, but the Bosch didn't have a brake. It just dropped. It used the airbag technology that Bosch develops and created a little bit of an explosion and dropped the blade down. The patent that Bosch allegedly infringed was one that didn't specify how the blade fell down. It just specified that it fell down within a certain amount of time, of a certain number of milliseconds. And so that was the difference of why they were able to get infringement of the one and not the one with the brake. Because I heard from a lot of people, the two saws work very differently. And that was true, but that's not how you determine infringement. You have to go to the patent to determine infringement, not the product. The product they release may be very different than the patent portfolio they have. A lot of companies do that because they actually will patent inferior versions of their product in order to stop competitors from trying to undercut them in the market.
And then they just innovate on that after they've basically patented and got a kind of a working idea, and then iterate from there. It's interesting. So SawStop gets called patent trolls a lot on my videos or videos on YouTube. You'll see that comment a lot. What does that term mean? And in your opinion, does SawStop abuse that patent system, or are they just using it to their advantage?
Let me start by saying that SawStop is the opposite of what anyone would reasonably consider a patent troll. The term patent troll came from the fantasy world where you had a troll that was charging you a toll to cross a bridge. What a typical patent troll will do is that they buy a patent or a stack of patents from another company, often a Fortune 500 company, and then they go around and look for infringers and then get a license from all of the infringers that they can find. They're also called non-practicing entities, meaning that you typically don't make a product and their only value is the IP that they own. SawStop worked exactly the opposite. As far as I know, they've never licensed their technology to anyone besides TTS that effectively bought the company. Instead, what they're using their patents for is to own the market, which they were physically manufacturing the saw. So in their case, they actually, when they started the company, they were trying to license the technology to a couple of saw manufacturers that all said no. And so they had to start their own business to do it. So in that scenario, they had to invest, untold millions in logistics and manufacturing and advertising. So they're just sort of getting the benefit of all their hard work from 20 years ago.
I agree. I feel the same way. I said that about it in my haters guide to SawStop, that they use the system to their advantage, and they're ones that put in all the time and effort. So earlier you said Mr. Gass had tried to get other companies to license his technology before he went into producing his own. So they passed on that. Why would these companies put it in now? When it's available, why would they want to put it in their saws now? So
part of the problem that they'll face when the patent's expired, right now they can't do it because as far as I know, there's no license available. There was a talk about 10 years ago that there might be regulations that would force them to license the technology. So that would be a different ballgame. Never came to pass. But once the patents expire, the difference now between then is they've proven the technology can work, and they know that it's safer inherently with that technology than without it. So basically, think back to cars that had the seatbelts put in, and in that case, I believe Volvo gave their patent away, if memory serves correctly, and it might not have been Volvo. I'm just going off memory here, but they allowed everybody to use the seatbelt system for free.
Right.
The seatbelt system was proved instantly effective, and then of course, really quickly, the federal government started requiring that it be put in there. In this case, I won't be surprised, number one, if in the next 10 years that governments start to pass regulations requiring the technology to be put in. But even if they don't, it'll really be up to the courts to decide, should these saw companies put this technology in? Because any attorney is going to say they could have put it in, it could have been done, They chose not to. They chose to make more profit, so they didn't put the safety equipment in, and now this person's, they chopped off their hand or whatever, and now they're going to sue for, products liability that I was talking about earlier. At that point, they're expected to make updates to their products over time when technology is available to make it safer.
So what would make a company not do it once it's available?
Really, I expect the argument for that to be, number one, there's no way that I could see a shopsmith being able to be modified to have that. I mean, I'm not saying never, because, a lot of creative people out there, but I don't see that, at least not the same technology working in anything like that. Number two, you have a lot of really, really cheap saws out there. Like you have these, the Craftsman saws that are sold for like $150 or something like that. I really don't know what the market is for that size and what percentage of them are cabinet saws. But like when you're dealing with cabinet saws and you're dealing with something that costs $2,000+, you're going to have very little incentive not to put the technology in. To me, it's only a cost thing.
Right.
They would have more liability by not putting it in after the patent's expired than they would if they just tried to say that their saws had always been safe, so they didn't need it, and they thought the table saws have inherent risks, because we know now there is technology that can improve the safety. Right.
One of the things I read on when I was doing the other video on SawStop was one of the people were quoted as saying, this is a loose quote, it's based off memory, but if they put it on the higher end saws and they don't put it on the lower end saws, that opens them up to even worse liabilities, because they have it on the more expensive saws, but then the people that can't afford them are just out of luck, basically.
Right, and that's the type of argument that any competent attorney is going to make in front of a judge, right, or a jury. They're going to say they didn't care about the people that couldn't afford the high-end saws, and they just were only concerned about their profits. That type of argument is effective. It's not a guarantee that would be adopted, but to me, it's common sense that it's not the argument I'd want to defend with, that I was making more money, and so I didn't care about cutting these people's fingers off. That's if I'm the company's attorney, I would avoid that argument.
Right. All right. So if someone out there has a patent idea, how do they go about procuring a patent?
To get a patent, you have to file a patent application. Now, if you file a provisional application, you have to file the non-provisional application within 1 year. And then you typically wait between 18 months to 3 years after you file the non-provisional application for what they call an office action by the patent office. 95 times out of 100, the patent office rejects your patent application,
really?
Saying that it's either not new or it would be an obvious variant of the technology that's already out there. And if it's like, in some technologies say it's not patent eligible, if it's like software or something like that. But in any of those cases, you have to provide arguments and amendments to the patent application for the examiner to change the examiner's mind. And then a couple of rounds of that, anywhere between one round, if you're lucky, and I've seen as many as 7 or 8.
Oh, wow.
Can get expensive. Then you can get a patent granted. My estimation for most people is it takes 3 to 5 years from the time they file to the time of a grant of a patent.
That's crazy. So, from the time you file the patent and all the back and forth, is your product covered, or no, because it's not patented yet?
No, so it's a gray area, and you technically don't have coverage until the patent issues. However, you can get damages for part of the time that the patent wasn't patented if you can show that the claims were close enough to the ones that actually granted. If you greatly change the claims of the patent during the prosecution, it didn't give notice to the people that they were infringing. So that's typically more of a damages question than an infringement question.
Gotcha. So the Festool Domino is another one of those controversial tools on YouTube, right? If you show it, people are one side or the other on that thing. And I always see in the comments, anytime I use it or talk about it, people will say, when the patent expires on the Domino, there's going to be so many competitors. What are your thoughts on that?
This one was like just out of curiosity. I had looked up as well, and to be honest, I cannot find a U.S. patent on that product.
Really?
I found the European patent that was filed, I believe, in Germany, France, and Great Britain. That appears to be the right one. And normally, the way that patents on Google work is you can just select the country that you want to see. And the U.S. isn't there. I cannot find a U.S. patent on that product. I'm not saying it's not there, but I can't find it. Somebody would have to show me. And then obviously, if anybody watching the video, leave in the comments if you know of a U.S. patent number that covers it, because I would be interested to find it. As I mentioned at the very beginning, I'm not being paid to do this. So I'm not going to spend 100 hours searching for that. But my cursory review revealed the German patent, but it didn't reveal a U.S. patent.
So hypothetically, if there is no U.S. patent on it, if someone made basically a Domino ripoff and got a patent on it in the U.S., or just not even, could they even sell it in the U.S., or would they fight them with the other patents? Can they do that?
That's a great question. So a patent, to be clear, a patent does not give you the right to make or use anything. A patent is what they call a negative right. It allows a patent owner to prevent somebody else from making and using it. And so the best example offhand that I'm aware of was in the early 1900s, one company invented the diode and a second company invented the triode for radios. Yeah. And in that case, you couldn't make the triode without making the diode. So if they made the triode, they would infringe on the patent on the diode. So they actually had to cross-license the technology. Going to your point, you couldn't get a patent on it because it's already known technology, and the patent office, the U.S. patent office, could use the European patent application that was filed as evidence that it's known. So they would reject a U.S. patent. That said, if you manufactured the device in the United States and a company doesn't have a patent on it, they cannot prevent you from making, using it, or selling it if they just have a foreign patent. The only thing they can do is stop you from importing it into those countries that it's there. But it's and I honestly don't know the European patent system enough to know all of the rules and regulations for exporting infringing devices or anything like that. But inside the U.S., if they don't have a patent, you cannot prevent a competitor from making and using and selling the product.
There you go. Somebody's making dominoes there. So we're talking about knockoffs. If a tool is a definite knockoff, you see them all the time, especially on, say, Temu or some of these other websites. I just ordered a bunch of stuff from Temu, and there are absolute knockoffs there that I'm going to show in a video. Would you consider buying that knockoff or the real thing?
I personally would try to buy the real thing, and the reason being, one of the criticisms we constantly hear is there's not enough manufacturing in the United States, and there's not enough of those type of workers available in jobs. And the biggest reason for that is because it's often cheaper to make things overseas, and these American companies or European companies are often investing millions and millions of dollars in development costs in order to come up with the new design for the tool. In addition to wanting good quality tools like you can get from U.S. manufacturers, I also just don't like the moral component. Theoretically, you're actually an infringer of a device if you buy a product that is infringing on somebody else's patent. The reality being that very few companies are going to go after individual users for that. But at the same time, it's pretty distasteful in my mind when we just allow infringing devices to come into the United States and do very little to protect our innovations. Because if we don't, you won't get technologies like SawStop because they'll be too hard to develop, and you won't be able to get any return on investment because somebody can just copy it so easily.
Yeah, I've purchased for research purposes. I've purchased like a micro jig, the gripper on Temu. It looks identical to it. Identical, and I know that the gripper, I'm almost certain it has a patent on it. I'm almost positive it does, but it looks identical. But anyway, if you're making tools, what's the dangers of, say, getting an offshore company to make those tools for you?
So one of the things that I've heard from multiple sources, and not so much for tool manufacturing, for at least woodworking, but for other types of products out there, is that a lot of Chinese companies, in particular, the Chinese companies tend to do this, is if you have a factory over there and they work 24/7 because they want to keep everything working 24/7, and you send them the molds for your product, they will want to run that factory 24/7. And if you only buy 2 shifts from them, they will sell the 3rd shift to somebody else using your molds. I've heard of that scenario from multiple people. So in that case, it's exactly the same as your product, because it's the molds that you sent them. And there's often the Chinese government won't do a whole lot to prevent that. So you pretty much you kind of assume the risk when you do offshore manufacturing. Yeah, they can do it cheaper, but that it comes at some costs there.
So with that thought, other than patents, how would you protect your tools other than keeping them manufactured locally?
It really depends on how big your company is. This wouldn't be applicable if you're just starting out. That you really need patents. But a company like my local company, Woodpeckers, that's just down the street from me, their products are so unique. You can identify them without even seeing what the tool is. You can identify that it's a woodpecker tool from its color scheme and its overall look and feel. That's actually a trademark issue called trade dress. When you make the same design language, and honestly, that's why all of those companies do that. Festool, Milwaukee, all of them, they all make their products to look, a certain way, so that even if they do not have a patent on it, if a competitor makes a product that looks like it came from them, then it's a trademark infringement issue because now they're infringing on the trade dress of the product, the look and feel of it, not how it's used so much, but just that people would confuse this infringing product for being made by Milwaukee or Woodpecker or whomever.
Huh. That's interesting. Do you have any educated guesses on what company you think, other than Festool and SawStop, will be the first one to bite and try to come out with a product similar to SawStop?
It's a great question, and if I had to guess, I'd say Harvey, because I don't expect Bosch to do it, because I wouldn't be surprised if we're not going to know, but if there might have been a settlement when they didn't, part of the agreement between SawStop and Bosch was that they wouldn't produce the saw for a certain number of years, probably even after the patent expired.
Yeah.
But Harvey makes really high quality tools, and it's sort of their space. So I would think them. I also really like that Allendorf, I think was the company that made the competing product, which he pointed out did not have a capacitive effect,
That's right.
Which is in every SawStop patent of how it detects the presence of the hand on the blade. They did a design around for that. So technically, I guess they're the first in the market.
Yeah. I think that technology can scale down fairly easily. It's cameras and a computer, basically. But I don't know how much research and how much time and efforts went into that to, how much money they have tied up into it to recoup before if they ever even try to recoup. I mean, they may stay in the industrial side and never come to the consumer. But it's just super interesting.
No, and that's a great point. I think in my mind, the real cost there isn't the sensing. It's going to be the mechanism to drop the blade below the table. And I say that because, interestingly enough, SawStop, when they first came out, cameras were expensive. That would have been a technology that you wouldn't be able to do for $100 with high resolution.
Right.
I mean, that's, it's a totally different world in 2023 compared to 2000 or 1999, I think, is when they first came up with the idea. So a lot of the technology for positional sensing of hands and stuff is going to get cheaper and cheaper as the computers get cheaper. So the real cost will just be the mechanism that drops the blade below the table.
Awesome. Anything else?
Well, just for your just as a reminder from the very beginning, I'm wearing a Shaper shirt just because I won this.
Awesome.
From when I was watching one of their sessions. I have no affiliation with them. I know they're owned by the same company that owns SawStop, but that's my only affiliation. I won it when I was watching one of their great videos. So
if somebody out there has a tool idea, or get something patented, would they be able to contact you to get those patents filed?
Absolutely. So, I actually set up a special email address for this called wood@tarolli.com, TAROLLI.com. So if you just send it to that email address, but I will do my best to answer questions and things like that for people that have questions about woodworking tools that they want to talk about patents.
So as far as woodworking goes, what type of products or projects do you like to take on personally?
So, it depends on who you ask. And if you ask my wife, she will tell you that my real hobby is tool collecting and not actual woodworking. I have I'm always that fool that sees the new shiny tool like the Shaper Origin, and I'm like, that's going to solve all of my problems. It's going to do everything for me.
I need that for my safety.
Yeah, just the most recent major tool that I purchased was on your recommendation, the Milwaukee track saw.
Oh, it's awesome.
I had been putting off buying a track saw for the longest time because it's too boring of a tool. Like it's not exciting.
Right.
I want the shaper type of thing, right? But I would say that to answer your question originally, I'm pretty eclectic on the types of things that I make. Really, it comes down to how long will it take me to make, whatever it is that I'm doing. If it's a multi-piece part, that I would try to shy away from. If it's something I can do in a couple of weekends, then I want to do it. It's really just a matter of the skill level involved. Is sort of how I make my selection. It's probably more common than what people want to admit.
I'm the same way. I'm like, oh man, I don't want to spend 2 weeks on that.
2 weeks, you can get anything done in 2 weeks. I usually measure mine in months.
Mike, man, I really appreciate you joining us, and we'll talk to you again Tuesday, September 26th, 7 p.m. Central Time here on YouTube. We'll do a live stream, answer any live questions anybody may have about the patents on anything, really. Tools mainly.
Yeah, absolutely. And guys, think of your and ladies, think of your questions, and I'll do my best to answer them live. And if we can't, we can always do a follow-up call later.
Thank you, man.